Good morning, everyone. The House Judiciary Committee will come to order. Madam Clerk, please call the roll.
Chair Breen.
Present.
Representatives Edwards.
Here.
Carter. Hope. Here. Arbit.
Here.
Devendorf.
Here.
Hoskins.
Here.
Cerniglu.
Here.
Fink.
Here.
Wenzel.
Here.
Wozniak.
Here.
Outman.
Here.
Johnson.
Here.
Madam Chair, you have 12 members present. You do have a quorum.
Thank you, Madam Clerk. Today, folks, as they say in one of my favorite movies, will be just a walk in the park, Kazansky. We're going to be voting out 2 bills and having a presentation on guardianship. We are doing this as a prelude to the guardianship package that we will be discussing at the end of the month. These reforms have been long time coming. They are absolutely necessary, and I'm looking forward to the good work that we have ahead to make sure that we are taking care of our elders. And so first thing we're going to do right now is we are going to, I'm going to read in some cards, sorry. We have Samantha Gibson from the Michigan Association of Counties supporting HB 4823 and 4920. We also have Trevor Van Dyke, Deputy General Counsel for the Michigan Supreme Court, submitting support for 4823 and 4920 on behalf of SCAO. And we're going to first take up House Bill 4920 from Representative Fitzgerald. I will take a motion from Representative Edwards to report report out HB 4920 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter. Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 12 yeas, 0 nays, and 0 pass. House Bill 4920 is reported with recommendation.
Thank you. I will now take a motion from Representative Fink to report out House Bill 4823 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter. Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 12 yeas, 0 nays, and 0 pass. House Bill 4823 is reported with recommendation.
Thank you so much. I would now like to welcome Ms. Nicole Shannon from the Michigan Elder Justice Initiative, otherwise known as MEGI, to give us a presentation on guardianship in Michigan. Thank you, Ms. Shannon, and welcome.
Thank you so much, Chair Breen and members of the committee. I am thrilled to be here today to talk to you about guardianship and conservatorship from 30,000 feet. I'm going to try to give you the 30,000-foot view in about 30 minutes. So we're going to be moving at 1,000 feet a minute. We'll see how much ground we can cover along the way. Just to introduce myself, my name is Nicole Shannon. I am an attorney at the Michigan Elder Justice Initiative. We're a private nonprofit that represents older adults and adults with disabilities in issues that are important to folks in the aging and disability population. I have a statewide practice that I started about 13 years ago. I was formerly at Disability Rights Michigan, which at the time was Michigan Protection and Advocacy Service. In my role now, in addition to representing folks who are subject to guardianship and conservatorship, I also support legal services lawyers who are representing elders who are victims of abuse, neglect, and exploitation across the state. And often those folks are involved in the EPIC adult guardianship and conservatorship system. I'm fortunate to regularly present to national audiences. I've done presentations through the United States Department of Justice, the American Bar Association, the National Center for Law and Elder Rights, and others. A few other hats that I wear, and I'll tell you what hats I'm wearing in this presentation versus the hats that I just happen to wear elsewhere. I'm a liaison to the American Bar Association Commission on Law and Aging. I'm also a member of the Elder and Disability Rights Law and Probate and Estate sections of the State Bar. Those are not the hats that I'm wearing today. Today, the hat I'm wearing is as an employee of the Michigan Elder Justice Initiative, and also one of the very fortunate folks who was an inaugural member of the Elder Abuse Task Force back when it started in 2019. So I'm going to be talking mostly about three things today. One, yes.
Before you do get started, I'm going to ask, would you prefer to take questions if they come up as we go along or wait till the end?
If folks want to, if you have questions, I feel like it's usually easier to address them as we go along. But I guess if we're running short on time, Chair, I guess if you'll help me.
We're good. I would prefer, members, if you do have questions, please ask them as we do go along.
Okay, great.
Thank you.
So I'm going to be talking mostly about three things. One, I want to give you that bird's eye view of what is the EPIC adult guardianship system. I'll talk about what it is and what it is not, because in the weeds, it gets kind of confusing. I'm going to give you 4 stories from some real Michiganders who were impacted by the system, and technology willing, you'll be able to hear from some of them, a couple of them in their own words. And then I'm also going to be talking about some opportunities that this legislature has to make a real impact for folks across the state of Michigan, because guardianship is something that can touch any one of us, any one of our families, any one of the about 10 million Michiganders that are out there. So what are we talking about today? I am focused on adult guardianship and conservatorship under the Estates and Protected Individuals Code. I'm not talking about minor guardianship under the Estates and Protected Individuals Code, and I'm also not talking about guardianship for adults with developmental disabilities under the Michigan Mental Health Code. And I'm going to talk in a moment about who falls into that category, just so we're all really clear about what we're talking about here. So what are guardianship and conservatorship? In a very, very 30,000-foot view, guardianship is when a court eliminates your right to act on your own behalf, and it gives those rights to another person or, in some instances, an organization. Conservatorship is that same idea, but only as it pertains to your finances. And again, this is a very, very general, not particularly nuanced description, but for our purposes today, that's where I'm going to start. I also want to define some terms. I just mentioned developmental disability, because we're not talking about adults with developmental disabilities, and I just want to be clear on who that category of folks are. Developmental disability under Michigan law, that's somebody who, before the age of 21, manifested a significant impairment in 3 or more major life activities. And I know that was a very lawyer definition to give you, but in short, that means before age 21, 3 of those activities might be mobility, it might be economic self-sufficiency, it might be self-direction. And so often when we think about developmental disabilities, we're thinking about maybe somebody who was born with a cognitive impairment. Maybe we're thinking about somebody who was in an auto accident at age 19 and sustained a traumatic brain injury. Those are folks who would fall in the category of developmental disability, and those are folks who are not included in this EPIC adult guardianship system. Legally incapacitated individual, that's who we're talking about here today with the EPIC and Estates and Protected Individuals Code. I'm going to be using EPIC as the shorthand for most of this. Legally incapacitated individual is somebody who's found by the court by clear and convincing evidence, that's the highest civil standard, to be somebody who, by reason of disability, cannot make or communicate informed decisions in at least some area of life. And so when we think about that category of folks, we might think about, we often think about older adults who maybe have Alzheimer's, dementia. We might think about somebody who's dealing with substance use or mental illness. But that would also include that same person who, instead of having an auto accident at age 19 and having a traumatic brain injury, maybe they had that exact same accident at age 22. They would be in the EPIC adult guardianship and conservatorship system if they were in any system at all. Protected person, that's just the same idea, only with conservatorships. And I'm mostly going to be saying guardianship. Most of the things that I'm going to say pertain to both guardianship and conservatorship, but I'll try to highlight those areas where conservatorship is a little bit different.
Can you please explain the difference between a conservatorship and a guardianship?
Sure. So guardianship and conservatorship. Guardianship is about and I'll talk more in depth, but those guardians are making decisions about every aspect of your life. And I'll talk more about all of those aspects, but that's kind of in control of the person. Conservatorship is only in charge of the finances, and that's the major, I can get into more nuance than I think you want in this presentation, but that's the main difference between the two. Okay, so I think maybe in a longer answer to your question, though, under a full guardian, and not all guardianships are full, but if you were to have a full guardianship under the Michigan Estates and Protected Individuals Code, what are these rights that we're talking about losing? These are bedrock rights that go to being an adult. If you are subject to full guardianship and conservatorship, you lose your ability to contract, and that means you cannot choose to get married. That is a right that is gone. Your guardian can choose to get divorced on your behalf. They can defend you in a divorce action. Your guardian is going to be making your medical decisions. That could be anything from a decision about major surgery to if you're living in a nursing home and they decide that no more hamburgers for you, we're only on a soft food diet. Speaking of nursing home, living arrangements, your guardian may be the one who decides, and you're no longer in charge of where you live. Your guardian may decide that you're not going to live in your home anymore. You're going to be moved into a nursing home or an adult foster care facility. The people who you interact with, visits, communication, activities with loved ones, these are choices that your guardian is going to be empowered to make on your behalf. And unfortunately, we've heard from so many folks who have been cut off from loved ones because the guardian has chosen to end those relationships. You're going to lose your financial and property decisions. Your guardian is going to be in charge of your stuff. And also in charge of your personal belongings. I just want to be clear here, a brief aside on conservatorship. Your guardian cannot sell your house. Only a conservator can sell your house, and that is with court action, but that is often too brief. And just because they didn't sell your house doesn't mean they can't move you. So your guardian could say, we're going to keep your house. We don't quite know what we're going to do with it, but you're moving into a nursing home today. Yes?
How often is it happening where a guardian is determining whether or not somebody can get married or is initiating a divorce on somebody's behalf? And are you seeing instances of abuse in that, or is that for the person under the guardianships for their benefit?
Marriage, so I'll say for the divorce, it's often strategic and related to Medicaid eligibility. Because often if somebody sustained some kind of an injury or they need medical care, there are often very, very difficult choices that folks need to make because if they're divorced, their spouse's assets no longer count for Medicaid eligibility. In terms of marriage, those are some of the most heartbreaking cases, particularly for folks who I think most people would see as being in the gray area of capacity. There's a phenomenal documentary called Edith and Eddie about two folks who are in their 90s who were married while one was under a guardianship, and so it wasn't clear if the marriage essentially counted. But it was just two people who wanted to spend their lives together. I mean, this is a real issue when it comes to relationships, when it comes to even just spending time together, trying to figure out if that person is allowed to, is it assault to hold hands with somebody under a guardianship? It gets really messy and challenging. Is it assault if they wanted to, share the same room if they're in a nursing home? It gets really difficult and sad and heartbreaking, I think, for folks who want to maintain relationships. But from a legal perspective, it gets really messy. It's absolutely heartbreaking, particularly for older adults who maybe find love later in life, who just want to spend time with their significant other. Thanks. And then additionally, the ability to appoint or revoke fiduciaries. I say it, I think my friends are all sick of me saying it, but the best way to avoid the gold standard for avoiding guardianship and conservatorship is to make sure you've got a durable power of attorney for finances and a patient advocate designation for medical issues. But once you are in the guardianship system, it becomes very challenging to do that because there isn't a lot of nuance when it comes to the capacity there. And if you were to execute those documents, they would almost certainly be challenged. So it's kind of, once the train has left the station, it's very difficult to go back in time and avoid guardianship through those processes. So I'm going to take you through kind of what is the process? How does this all work from start to finish? Well, it all starts with some precipitating event. Something has gone wrong. Somebody somewhere is worried about the person. And they also have to think or at least they're supposed to think that they are legally incapacitated, that by reason of disability they can't make or communicate informed decisions, but also that guardianship is necessary. Like I just mentioned, maybe there's a durable power of attorney or designation of patient advocate. Maybe the person has supports in the community and guardianship wouldn't be necessary. And also say this is usually really messy because the folks who are petitioning are emotional. They don't know about all of the options and resources, and they see guardianship as the solution to the problem, even when it isn't. And so the law contemplates that something has happened to cause this person to lose capacity in at least one area of their life, and that there are no alternatives. And I put an asterisk next to alternatives to remind me to talk about, like I said, durable power of attorney, supports out in the community, supported decision making. There are a lot of times where somebody may, have capacity issues, but guardianship is not necessary to solve that problem. With supports in the community, with banking, where folks can do view only, through Social Security representative payees, through supports in the community to make sure that folks can get in and out, get their meals, and get to medical appointments and things like that. There are a lot of ways to avoid guardianship. And the law contemplates, like, we've tried everything, and this is the last resort. And where it goes wrong is maybe the person doesn't lack capacity, and I'll talk more about that later, and also that there are some alternatives out there. So step 2, the petitioner under existing law is supposed to be advised of alternatives. And I'll take this moment because I talked about under existing law, because you might be asking, why do we need this? Our current laws, if we just enforced our current laws, then we'd be okay. And I would say, EPIC was passed many decades ago, and we've seen that there is a big disconnect between the words on the page and how they're being interpreted in actual practice. And this is an opportunity for this legislature to learn from those decades of practice with EPIC and to really make Michigan a leader. So the law contemplates that the petitioner is going to get some information alternatives. They're panicking because mom is in the hospital or because mom just had a fall. They're panicking because there's something awful happening, and they're going to take the time to read the pamphlet in the lobby and decide, oh, maybe this isn't really what I need to do there. And I will say that some courts really do try their very best to provide this information, but the system just isn't set up very well for folks who are in a crisis to really do a quality evaluation of those alternatives. Where does it go wrong? Again, somebody's in crisis. They need to seek out this information. They don't know where to go to get help, or the information is way too general, it's hard to understand, or it really doesn't apply to that situation. The next step, somebody out there is going to file this petition. Typical filers include Adult Protective Services, hospitals and nursing homes, loved ones, and it's really, the law contemplates it can really be anybody who is concerned about this person. And also the law contemplates that they really know who this person is, that they understand all the nuances of their life. Where does it go wrong? Well, sometimes petitioners are using this system to solve their own problems. Family and friends are seeking control. Daughter doesn't like the way son is handling mom's affairs, and so daughter's going to go get a guardianship. Maybe somebody is being even more nefarious and they're trying to exercise control to exploit this person. Sometimes nursing homes use this as a tool for debt collection. They say, oh, you must not have capacity to pay your bills because our bill isn't paid. So we're going to make sure that we can find somebody who will pay that bill. Hospitals sometimes use it to eliminate or reduce their liability, or to find a way to discharge somebody who might be particularly challenging. And we've also seen there are some contractors that work on behalf of hospitals and nursing homes who've never actually met the person, but they're hired to go file these petitions to get things moving. If there is an emergency, because a lot of times, the law contemplates, and this is true, there are emergencies out there where somebody needs to be able to act immediately. And if that happens, the petition might be granted on an emergency ex parte, that means without notice or hearing basis. But once that happens, it is very difficult to unwind and go through the due process protections for the individual. So we need to be very careful about when we're granting these emergency petitions. And I also want to point out that unlike the Michigan Mental Health Code with guardianships for adults with developmental disabilities, EPIC does not require any medical evidence. And so it can be purely on the testimony of lay folks discussing what they see as somebody's incapacity and lack of alternatives.
Question about those emergency hearings.
Yes.
When somebody does file a petition, what is the typical turnaround from the filing to the actual hearing?
So the actual hearing under kind of like regular order would be within 28 days. In some counties, it's slower. The main barrier is the requirements for notice, and so it's basically a 14-day notice period in probate courts, and so typically 3-4 weeks out is as fast as you can go. In some courts, it's slower, and that's not what is allowed, but that is how it happens. And so if you need something to happen sooner than that kind of 21 to 28-day period, because there is a true emergency, that's when you'd be looking at filing that emergency petition.
So for the emergency petition, though, like, yeah.
Like 24 to 48 hours, which is pretty standard for most courts on any kind of emergency TRO or temporary restraining order. That's standard practice. I can't say for, there's 79 different probate courts and they're all going to have their different practice, but most probate registrars take it very seriously and get things moving as fast as they can in those when it comes to those cases.
Oh, thanks.
Yep, thanks. So next step, I care very deeply about this one, and so I'm going to try not to get too hung up on it. This is the guardian ad litem, and I think they're kind of like the unsung protagonist of guardianship, of adult guardianship hearings. The court has to appoint a guardian ad litem. This person does not have to be a lawyer, though they often are. The idea is they're going to meet with the person who's subject to the petition. They're going to say, hey, somebody filed for a guardianship. And then they're going to tell them about all of their rights. This is where we're talking about truth, justice, and the American way. We're going to say, you get a lawyer, there's going to be a hearing. You can have an independent evaluation, and you can object. You have your opportunity to tell your side of the story. And then the guardian ad litem reports to the court. And so the law is contemplating that the guardian ad litem is going to be really effective in communicating to folks who may often have disabilities that make it difficult for them to understand, that the GAL is going to adequately convey the gravity of the situation so that the person understands, hey, you can't get married to your loved one. You're not going to get to choose where you live. You aren't going to be in charge of all of these things. So the law contemplates that the GAL is going to convey it to this person so that they can take the action that's necessary. So where does it go wrong? Well, often I think they soft pedal it. The guardian ad litem doesn't adequately communicate the gravity of the situation. The guardian ad litem, when they're reporting to court, is substituting a best interest idea as opposed to the capacity and necessity standard that is under the law. And so they might not like that somebody who's 90 years old is living by themselves in this house. Maybe that feels dangerous to them and they don't like it. That doesn't mean the person lacks capacity. It doesn't mean it's necessary, but they just might not like it. It might not jive with their personal values, which is not what the law contemplates. The GAL says incentives to keep things moving. They're appointed by the court, so they want to keep the judge happy. I think they're trying their very best to be, to do the right job, but there are incentives that make them want to, ensure that the judge is going to be happy too. And I think most importantly, and I could talk for hours about this, the court is relying on the guardian ad litem report, despite the fact that this is a civil rights hearing where we should be having, a full evidentiary hearing, a full adversarial hearing about these things. But unfortunately, in a lot of situations, whatever the guardian ad litem is saying, sometimes with like second and third hand hearsay, that is taken as, the absolute truth, and that's what the judge is basing their decisions on. And so it can be very challenging. I think most experienced advocates know if there's a guardian ad litem involved, their job is to get to that person as fast as possible and poison them against everybody else, because they know that the judge is going to be listening to the guardian ad litem, and so you better get in there and tell your story and your client's story as fast as possible, which is not what we want in these cases. We want there to be hearings out in the open with the rules of evidence so that a judge can make a decision based on high quality information instead of based on the say-so of a guardian ad litem who's trying their very best, but the system is just not set up to essentially have somebody give a report to the court so that the judge is making decisions in these major civil rights cases. So then we have the hearing. We have the hearing. The law contemplates we're going to have a full adversarial. This is going to be a full-blown bench trial. We're going to call witnesses. There's going to be cross-examination. There's going to be evidence. And everybody involved is going to have the opportunity. And that includes all those interested persons, those family members and loved ones. Where does it go wrong? Often the person is not there. Maybe their transportation is very challenging. They might be in a nursing home and nobody made arrangements for them to attend. Maybe they can't get out of their house, and I'll tell you more about somebody who had that situation later on. Often the guardian ad litem's report is, like I said, given outsized influence. And I want to say, too, I know many guardians ad litem out there who are working, and they are doing exemplary jobs to provide high-quality information. But the system is not set up to give their reports the due weight compared to everything else. Emotions run high. You've got judges that are, trying to wrangle a lot of folks who are very upset, who have never been in a courtroom before and don't understand procedure. So these are challenging cases. And sometimes parties are pressured to agree to guardianship without really understanding the consequences. Sometimes the folks are told, well, don't you just want somebody to help you? Wouldn't it be easier if somebody helped you? And it's really easy to say yes to help in those situations. So then we get the order. The court has to make a decision here. The court's going to issue an order on the petition. And so the law contemplates that if the court finds, and I'm sorry to get into like the lawyer thing here, but you have to find by clear and convincing evidence that top level of civil evidentiary standards. Two things. One, the person is legally incapacitated. They, by reason of disability, cannot make or communicate informed decisions. And so that's number one. Number two is it has to be necessary. So you might have somebody who's incapacitated, but they've got a durable power of attorney, they've got a trust set up, they've got a patient advocate designation, they've got all of their affairs handled. They already appointed the folks who are going to handle things for them. There's no real role here for the guardian. And then the court, assuming that they are making this appointment, they're supposed to appoint the person with the highest priority who is both suitable and willing to serve as the guardian. Right now in EPIC, there is a guardianship hierarchy, and it starts with the folks who are closest, your loved ones, your adult kids, your parents, your siblings, those blood relatives. And then at the very bottom of the list is a professional, if there's nobody in your life who is suitable and willing. And I'll say right now, that doesn't exist in conservatorship. There's not that same type of, analysis. So where does it go wrong? Well, a lot of times the clear and convincing standard isn't really met. I think that the judges are receiving the information. It's not always great information, and it's not always meeting that high, clear, and convincing standard on one or both requirements. A lot of times full guardianship is granted even when it isn't appropriate, because the court is supposed to be doing a really detailed analysis and saying, okay, you might not be able to handle your finances, but you can handle going to the grocery store, where you want to live, you can handle these aspects of your life. And unfortunately, often, these cases result in full guardianships where they really are not necessary. And then finally, and any of you who are participated in kind of the listening tours across the state, I'm sure may have heard, folks with the priority, those family members at the top of the list, are often passed over in favor of folks with lower priority. And when I say folks with lower priority, I mean professional guardians. And just to go back, and that's because, suitable and willing are kind of mushy words. The Court of Appeals has tried to sort out what suitable and willing mean, but I think, as I'll talk about later, there's an opportunity for this legislature to really clarify what is suitable and what is willing. So after the hearing, guardian has to visit every 3 months. They have to file an annual report. Conservators actually have to take an inventory of all of your stuff, all of your finances, your real estate, your cars, your personal belongings, and then every year after that they have to file an annual account. The law contemplates this is the least restrictive way to handle this. The law contemplates the guardian is going to get to know you and your values. And the law also contemplates that someone somewhere is going to tell the court if something goes wrong. It goes wrong because some corporate guardians delegate their duties. So there's not that one-on-one kind of personal relationship. Let's say if a family member were the guardian of their parent. Some corporate guardians have upwards of 1,000 different folks they're serving through their corporations. And so delegation is the name of the game. I'll talk more about that later on. Guardians don't have any qualifications. Well, I won't say that. I apologize to guardians out there. Many guardians have sought out qualifications and have backgrounds in social services and have gotten certifications, but the law does not require that they do that. They've done it purely voluntarily. There's no training requirement, and there's no limit to the caseload that guardians are allowed to take on. Additionally, the court doesn't have any responsibility to review any inventories or accounts, and guardians aren't filing any accounts at all. They're not required to do it. And so it's completely opaque, and it leads to a lot of consternation when folks assume, correctly or incorrectly, that their guardians are doing something fishy with their money. The reviews are really inconsistent across the state, and I'll say just neglect and exploitation are extremely hard to detect in these cases because we have to hope that somebody somewhere is looking at these cases.
Ms. Shannon,
Yes.
for the, I get, for lack of a better word, lay guardians, family
Yes.
members, what resources are available? Because I would imagine if suddenly you find yourself in charge of your parents' life,
Yes.
that's a heavy, heavy burden.
It is.
What resources right now are available to help people navigate those waters? Because if you're taking over somebody's bank account, trying to get them to the doctor, get access to medical records, is there anything available for them as far as trying to figure that out?
So I'll say that it's wildly inconsistent across the state, and some probate courts have done an exemplary job of trying to support lay guardians, those family members. They hold regular trainings for folks who are going to be serving as guardians and conservators, but it's not the case across the state. And it's definitely an area where there's a need, because often folks will feel like they're not equipped to handle it, or that maybe let's leave it to a professional because they're a professional after all. And if family members felt like this is something they could do, if they were truly supported in this, I think it would take the strain off of the corporate guardianship system, because they, have so many folks to serve, and it would better serve the individuals, because it's so much better when you've got somebody who understands you and your values, who is handling your affairs, as opposed to somebody who's just met you. So it's definitely an opportunity for across the state to find those courts that are really doing it well and use that as a jumping off point.
Are family members or lay guardians, do they pay themselves any type of salary or wages in order to do this for their own family members? Because it is time consuming. They have to take things out of their lives in order to accommodate that.
So you can pay yourself a reasonable fee, as can professional guardians. So there's no real differentiation there. If you're a professional serving somebody who is in a nursing home, and they're on Medicaid, which most folks in nursing homes are, at least in my universe, because I tend to serve folks who don't have a lot of means, the guardian's paid $83 a month to do that. If the guardian's trying to serve somebody out in the community, then that person really doesn't have anything beyond Social Security, they're not getting paid anything. And so the same is going to be true of lay guardians and professionals. And so it really comes down to, does the person have means, and then also, are you doing a good enough job keeping track of the time that you're spending on all of this, and requesting payment through the court's review. And so I'd say most folks, it's just not worth the time. In my anecdotal experience, if you're taking care of mom, it's unless mom has substantial assets, and in that case, you probably aren't her guardian because she has a trust and she's got a power of attorney and she's got all of these other things. It's not worth the administrative hassle to do it.
Okay. Representative Fink?
Yeah, if I could just ask a quick question about, you've mentioned a few times, and thanks for your presentation this morning. You mentioned a few times differences that you observe across the state.
Yes.
Could you just give us maybe a little bit of a flavor of what that means? I mean, the two counties I represent are both, well, I represent a small portion of Lenawee County, which is around 100, maybe 115,000 people. Mm-hmm. Then Branch and Hillsdale County, around 45,000 people, yet all of these counties are in the top half of the state by population in the county. So my assumption is that the variation at least partially depends on the size of the population of the county and the corresponding resources that the courts have for, guidance for lay guardians or what have you. But can you just say a little more about what you mean by variation across the state?
Sure. And I think that I think some of it does have to do with population resources. I think some of it has to do with, and I'm saying this because there's a retired probate registrar sitting right over my shoulder who did an exemplary job in Kalamazoo trying to develop some of these resources. I think some of it has to do with, how devoted is that court staff to this issue? How devoted is this very overworked court staff to establishing some of these resources that are going to be available for folks? And so I think that's a lot of it. It really has to do with how the individual court prioritizes this compared to everything else that's on their plate. And I want to be clear. I know that the courts are, they are burdened. They have a lot on their plate, and this is just one more thing, and it's optional. And so that makes it easy to say we'll get to that later. But I would say it's not necessarily a rural, urban, or a high population, low population divide. I think it has more to do with, how devoted is that particular court to getting these resources in place. So I don't know if that answers your question. Thanks. Okay. So I want to change gears right now and give you a little bit of, true life examples. I've got 4 stories from folks across the state of Michigan. I want to start with Robert Mitchell and Barbara Delbridge. Many of you may have heard about them because they were in the news a few years ago. They were aging, and Robert's daughter, Barbara's stepdaughter, realized that maybe they needed some extra help. She spoke to their financial advisor, who suggested that maybe she get a power of attorney over Robert and Barbara to help them with their finances. But unfortunately, by that point, it was too late. They had, I believe, fairly advanced dementia, and they really did not have the capacity to understand what would be involved in executing a power of attorney. And so their stepdaughter was told, guardianship, it's necessary. They don't have any other alternatives at this point. So she went and she petitioned for guardianship. Unfortunately, the court in that case passed her over in favor of a corporate guardian, because the court felt like she was not suitable because she hadn't tried to stop her dad and her stepmom from engaging in some activities that they'd been doing, which she didn't have any legal authority to stop them. They're adults and could make their own choices. And so she was passed over in favor of a professional guardian. That professional guardian built a 6-foot fence around their home, kept the family members from visiting Mr. Mitchell and Ms. Delbridge, and they paid themselves about $200,000. Fortunately, folks intervened, and the Attorney General's office intervened. The stepdaughter was eventually able to become guardian and conservator of both her father and stepmother, but shortly after she was able to secure that legal victory and get them back in charge, of being able to visit with loved ones, they passed away very shortly after that. This is my client, and if in technical abilities willing, you'll be able to hear him in his own words. His name is Roderick Gordon. He became deaf-blind in his 20s and 30s due to a brain tumor. He was attacked outside of his apartment and hospitalized. He'd been running his own life for years. Wednesday was laundry day, Thursday was grocery day. He handled his own affairs without issue. He was attacked, he was hospitalized, and then when he was discharged from the hospital, all of those services that he had carefully crafted over decades of living in the community, they just weren't in place anymore. And so when he was discharged, he didn't have anything to support him. Adult Protective Services got involved and petitioned for guardianship. Nobody told Mr. Gordon about it. The guardian ad litem went out to visit him, realized that he couldn't communicate with Mr. Gordon because Mr. Gordon uses tactile ASL. When you sign into somebody else's hand, I think the only, example folks might know is, Helen Keller signing into somebody's hand. They didn't do that. Mr. Gordon ended up under a guardianship and was sent to an adult foster care home. Despite the fact that he has full capacity, just nobody really communicated to him, and he wasn't able to attend the hearing that he didn't know about. So I'm going to see here if we're able to hear from Mr. Gordon. If not, I'll move on.
Must change.
I do want to see others who have the capability and are willing to continue their life to be given the correct chance of living independently and not to be just picked up and dumped into homes where they are not supposed.
Where they are not supposed to be. So that was me cutting it off too short. But that's Mr. Gordon expressing in his own words how he felt about the situation.
Must change.
Let's see. This is another example. Bessie Owens is somebody who is represented by one of those legal services attorneys I mentioned at the beginning. Mrs. Owens wasn't able to handle her own affairs because she couldn't get out because she needed a wheelchair ramp. She needed a wheelchair ramp to be able to, get out, transact her business, go to the bank, go grocery shopping. All she needed was a wheelchair ramp. When she asked for help in getting the wheelchair ramp because she couldn't get out, There was an adult protective services petition for guardianship over her. She wasn't able to attend the hearing, again, because of her transportation issues, but she doesn't lack capacity. And it was all because she asked for help in trying to get a wheelchair ramp. And I've got 20 seconds of Ms. Owens just kind of.
I do not need no one to oversee my finances or a guardian. I'm mentally capable of transacting my day-to-day business. I do not need that. I need a ramp to be able to leave my home when I need to.
So I mean, that says it all, really, from Ms. Owens in terms of what she needed and what she ended up with. And then my final real life example, this is a case that was just decided by the Michigan Court of Appeals, and it's currently pending before the Michigan Supreme Court. Mary Ann Malloy and Dana Jenkins are two folks who were involved in auto accidents, and they had a professional guardian appointed to handle their affairs. In the case of Ms. Malloy, that professional guardian delegated to somebody else 98 out of the 99 tasks performed during a certain period of time related to that guardianship. When that professional guardian sought payment from the auto insurance company said, no, you didn't actually do this work, and you're not allowed to delegate in this way. And so this is a case that this case was taken up in Oakland, but there are virtually identical cases in Genesee and in Grand Traverse counties that are on hold awaiting a decision from the Michigan Supreme Court. But the Michigan Court of Appeals said, no, you can do that. We're okay with our professional guardians delegating 98 out of 99 of these tasks. The Michigan Supreme Court might come to a different conclusion, but I think when we think about guardianship as this benign protective device where somebody's going to make sure that grandma's taken care of, that grandma's in a good nursing home, and somebody's taking care of her finances, there's far more to it than that.
Representative Fink.
Thank you. So on this question of delegation, I understand it could create a problem. But as I'm thinking about most of the professional guardians clients are these $83 a month folks. And if you had, I'm not good at math, I'm about to do it in public, and I am a Marine, so this is not necessarily going to go
Hey,
well.
I'm a lawyer, so I can't do math either.
Yeah, well, I'm doubly damned because I'm also a lawyer. So, but $83 a month times like, say, 50 clients is only like $50,000 a year. So if you're a professional guardian and this is more or less how you get by, I mean, is this a realistic? I mean, so then to say like, and you can't delegate any of this. Just is this a realistic? What are we really talking about? Sure. It doesn't sound possible.
Sure. So I'll say this is something that guardianship organizations, and I get tagged sometimes, I have a lot of respect for the work that good professional guardians are doing. This is something that good professional guardians are already doing. They've got a staff of folks who are certified under their own voluntary certification. So that means folks who are trained, who are ready to handle these cases. And typically the way they handle their cases is they're kind of given a caseload. Like you're assigned to, Wilma, Selma, and Jean, and like these 50 other folks.
So I don't want to interrupt. Are you talking about like companies? I'm sorry, I did want to interrupt, but I don't mean to be rude when I do interrupt you. I mean, like, so you're talking about like a company that's got like a handful of employees and then many clients.
Yes,
okay.
And so typically the way it would work is you're kind of given your caseload, and this does vary, but this is the practice at many guardianship companies that I'm aware of. If you need to have one of your colleagues go out and handle something on your behalf, under the proposal, I believe that it is. Let's see here. It's 4909. We're doing 5106 sub 6. You can certainly delegate to your trained colleagues who know what's going on to handle these things. What you can't do is ask anyone off the street to do it. You can't ask the receptionist who's answering the phones to consent to medical treatment. And so absolutely, this is something that needs to be done thoughtfully and carefully, because I agree with you. We don't want to overburden, we don't want to overregulate, but I think what we can do is look at those models that are already being used across the state and being used well. And so if you want to delegate to your colleague who is trained, who understands the gravity of the situation, then great. But that doesn't mean that you can ask the intern to go in there and sign the contract. Thank you. Thanks. So opportunities for this legislature. I know folks love pop culture references, and so there is a very fictional, I want to be clear, fictional movie on Netflix called I Care a Lot about things related to guardianship. It sounds like there's a fan down here. Okay. Britney Spears has brought guardianship into, back into the spotlight. And as a millennial, it's made it very easy for me to explain my job. But it's also been a focus of national press, New York Times articles, Bloomberg News, and then, a few years ago, there was a professional guardian in Nevada who was sentenced to 40 years for ripping off all of her clients. This is a national issue, but Michigan can truly lead in this space. Some issues that were identified by constituents during the listening tour that took place shortly after the beginning of the Elder Abuse Task Force. These were the things that I heard time and time again, and that I think many of you and your colleagues heard as well. Family members being passed over in favor of professionals, a lack of transparency about finances and treasured items, folks who were being moved out of their homes into institutional settings like nursing homes, and like you heard Mr. Gordon talk about, into an adult foster care home, folks who can't go to their own hearings like Ms. Owens and Mr. Gordon. That delegation that Representative Fink just discussed, and then having a really hard time visiting those loved ones who are subject to guardianship, because they're often, and this is not a professional or a layperson thing, this happens because professionals get frustrated with the folks who are visiting and maybe causing problems. This happens with families because the brother doesn't want the sister visiting and it's a power play. It's really challenging. Some of the issues that the task force members identified, and so we were mainly practitioners or professionals in the area, we identified a lot of inconsistency in these 4 areas. The role of the guardian ad litem. Some courts are getting novels that detail every family tiff over the last however many years, and somebody in this room once told me that probate court fights are not really about the petition, they're really about who got the best birthday present in 1987, and so that's all documented there for the taking in the guardian ad litem report. Sometimes it's just a really quick spiel, just a 1-page briefly filled out form. Case scheduling orders are kind of all over the place in terms of the time that you're given to really make this into the full adversarial hearing that it deserves. There's a lot of inconsistency about what constitutes an emergency practice regarding temporary guardianships that are meant to be temporary. And then also appointed counsel, they're really minimally compensated for these cases. And this can be a full adversarial civil rights trial. And it can be very challenging to prepare and be a zealous advocate in those circumstances.
Is it safe to say one of the other major issues is payment for the professional guardians? I know that Representative Morse has been trying to help untangle some of that. $83 a month isn't much. And then some professionals are appointed to certain individuals and they get nothing for what they do.
Absolutely. I think that it's a huge problem, and I don't disagree with that at all. I've often said I think 2 things can be true at the same time. Guardians are underpaid, but also the due process protections that we have for folks along the way on that road to guardianship, they just are not working right now. And so I think a big opportunity for this legislature is to make sure those protections are working, that there are true alternatives to guardianship, so that we can help at least not further burden that system of professional guardians. And that's my expectation through these laws, through these bills that you're looking at, and then others to come. But also, like I said, 2 things can be true at the same time, and absolutely, we need to make sure that family members and professionals are all given the resources that they need to make these important decisions, because when you're taking somebody's rights, those important rights that we talked about before, and handing them over to somebody else, we need to make sure that they have every incentive in the world to do right by that person.
I would also add, it seems that instances of fraud, especially financial abuse, I met with a professional guardian the other day who mentioned that she went to look at her client's bank account and saw that there was a regular transaction to another account, which was held jointly between her client and her client's daughter.
Yes.
And then money would go out of that account to an account held solely by the daughter. And there was nothing that the professional could really do. And I think there needs to be a better,
Absolutely. And
more accountability in that aspect.
more accountability and more transparency. I can't tell you how many calls I get from folks who are convinced that their guardian is ripping them off, just because they don't know what's happening. That money just goes into a black box and they have no idea what's going on, and so they assume that they're being ripped off. Once we're finally, a lot of times through a lot of pulling of teeth to get those financial records, we're able to look and say, no, but this is how your money's being spent. Nobody's stealing from you, but it's fair to be frustrated that you're an adult who has no idea what's going on. I think if there were more transparency, then there wouldn't be that level of suspicion, that there wouldn't be that time wasted, that folks wouldn't be going to probate court going, I'm sure they're ripping me off. I don't know how, but I'm pretty sure of it. And so there are a lot of opportunities there. And then also, not just that, but to make sure to have eyes on it, because the courts aren't looking. The courts are not looking at these accountings to see if something's going wrong. They're just sending it out. And I've been told by probate judges, we are a notice and object state. That means that it's not up to the court to look and see if something is fishy. It is up to somebody somewhere to object to it. And so the more transparency that we can get to make sure situations like that don't happen, but also more to your point, which is, we need to make sure that folks feel adequately compensated to avoid fraud. Absolutely.
Well, in this instance, it was the person under guardianship. It was her own daughter that was ripping her off.
Yeah.
Which obviously the professional guardian wanted some additional resources to make sure that she could put an end to those transactions, and she couldn't.
Absolutely.
Okay.
And that is something something we've dealt with, and something that came up in front of this committee before, the inconsistency that financial institutions have when it comes to handling durable powers of attorney, folks who need to act right now to fix that fraud, and having the banks go, well, we got to send it up to legal and things like that. And so I appreciate the work that this committee took in the Durable Power of Attorney Act that got voted out of the full House to make sure that folks can act. But that's another area. Same circumstances, just a different piece of paper. Power of attorney versus letters of guardianship. Absolutely. So how can you lead? Boy, this is a long list. Don't worry, I'm not going to read it to you. But all of these things that I talked about in here, all of those things where the hopes and dreams of our current law don't quite match up with the reality of practice, these are things that this committee, I'm hoping, will address in House Bills 4909 through 4912. Figure out when you're passing over family members and why. Come up with a uniform standard for emergency guardianships. Make sure that these guardian ad litem reports are actually going to be delivering high quality information. Don't move folks out of their houses unless you have to. I mean, I could go through all of this, but you've given me so much time, I don't want to take any more of it. I'm happy to answer questions from folks. And some other issues for consideration, like I mentioned to Representative Fink, a lot of these things good guardians are already doing. I'll also say families are complicated, and some of these proposals understand that families are complicated. But finally, this is civil death. This is what scholars refer to it as, civil death. And it needs to be treated with the seriousness that it deserves. And so I thank this committee. I'm happy to take any questions, but I know I've taken a lot of your time.
I thought it was a great presentation.
Thank you.
And for a lot of our members who are not attorneys, who are not familiar with these issues, this is what we're going to be tackling. We will not be meeting next week, but the week after, I do hope to take up the guardianship package that we have. We have already dropped 4 bills. There is a 5th, which is to establish the office of the state guardian, where a lot of these things will be funneled through. It is the intention that the Office of the State Guardian will help to develop resources for lay guardians to streamline a licensing process so that professional guardians are certified and licensed in the state, and to set standards for professional guardians. Thank you. This was a very good presentation, in my opinion. I hope everybody was at least paying attention. Does anybody have a question? I know that Representative Wozniak has been a champion in this area.
Thank you, Representative.
And so thank you for all your leadership and a lot of the work that you've done to help get us here. Anybody have questions, comments?
You know where to find me.
Okay. I'm going to take a, thank you very much, Nicole.
Thank you.
Appreciate all of your work. I'm going to take a motion from Representative Edwards to excuse Representative Carter, and also a motion from Representative Hope to adopt the minutes from the previous meeting of September 6th. Those are now adopted, and no objection. Those are adopted, and with that, guys, we are, wait, Yep. Seeing no further business before the committee, we are adjourned.